Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to talk about lack of testamentary capacity as a cause of action in Illinois will contests. So let's first talk about what a will contest is. A will contest is a dispute in an Illinois probate case where one party is claiming that for one reason or another the will is invalid. In order to do that, you have to have a cause of action. There's several causes of action: fraud, undue influence, revocation, and failure to comply with the formalities of will execution are some causes of action we've talked about in the past. Today we're going to talk about lack of testamentary capacity as a cause of action. And that's basically an argument that at the time the will was executed, the person who executed it didn't have the mental ability to understand what was going on and didn't have the requisite mental capacity to make the will, therefore the will is void. So in order to have testamentary capacity or the mental ability to make a will, you have to be able to know and understand three things. One is you have to know and understand who your immediate family members are, including your children. Two is you need to be able to understand the types and amounts of property that you own. And three is you have to have the ability to plan for the disbursement of that property through the will. So you have to have the understanding of what you're doing in making the will and dispersing your property to your loved ones. If you don't have any of those three abilities at the time that you're making your will, then your will is invalid because you didn't have testamentary capacity to make a will. The burden of proof is on the person trying to argue that the will is invalid. So there's a presumption of testamentary capacity that can be rebutted by disproving one of those three elements. You don't have to, if you're trying to disprove testamentary capacity, you don't have to prove that on the very day that the will was executed, the person was mentally incompetent. That's ultimately what you're trying to show, but you don't have to provide evidence from that day. You can provide evidence that they were mentally incompetent near the time that the will was executed, and obviously the closer in time that evidence is to the time the will was executed, the more compelling it is. So if they were examined by a doctor a month after the will was executed, that might be good enough to prove that they didn't have testamentary capacity on the day that the will was executed. If they were examined a year or two after the will was executed and found to be mentally incompetent, then that's going to be less compelling than the examination shortly after the will was executed. So let's talk about what type of evidence can be used to prove mental capacity or disprove it. Commonly, people will call expert witnesses, so physicians, are a great example, or psychologists. Also, they'll provide medical records. Now, the expert witnesses don't have to have actually examined the person while they were living in order to present testimony. Certainly, that's more compelling than after-the-fact opinions. But the experts can take into consideration anything that that anyone in their field would normally evaluate, even if it wouldn't be admissible as evidence. And they can render an opinion even if they'd never met with the person or examined them during their lifetime. Non-expert testimony can also be admitted. So the opinion of lay witnesses can be admitted to prove basically that they knew the person and they can give their opinion about their mental capacity. So that's really the foundational information you need to know about lack of testamentary capacity. We're going to talk about two more things: how it works, how lack of testamentary capacity works when there's a guardianship in place or when there had been one in place, and something called presumptively void transfers to caregivers. So let's talk about guardianships first. A guardianship, and we've got lots of videos on this at learn-about-law.com, but a guardianship is basically when one person is deemed to be mentally disabled by a court and another person is placed in charge of their personal or financial affairs or both. And a guardianship can be a limited guardianship where the person basically is found to be able to make some decisions but not others for themselves, or a plenary guardianship where the person basically is found to be unable to make any decisions for themselves in the financial or personal arena, and a guardian is named to manage all of their affairs. So that's a plenary guardianship. Appointment of a guardian does not automatically mean that the disabled adult lacks testamentary capacity. If they have sufficient mental capacity to meet that three-pronged test we talked about earlier, understanding their family, understanding the property, and understanding what they're doing in dispersing their property, even if they have a guardian appointed, they don't necessarily need the guardian to sign off on the will, or they don't need a court approval of the will in order to create a valid will. There is one complication, though. In 2016, there was a new statute that came out that basically said that if there's a plenary guardian that's appointed, one that manages all the affairs of the disabled person, then a rebuttable presumption arises that any will that's executed after the guardian is appointed is void. Now, this only applies to wills that are executed after January 1, 2016, and that were not approved by the court. And again, it's a presumption that can be rebutted by showing that, in fact, the person who was under the guardianship had the mental capacity to understand their children, their property, and the disbursement of their property. So let's now talk about presumptively void transfers to caregivers. So a lot of times when someone gets very, very old, they have a live-in caregiver, someone who's very close to them, giving them care. There's a statute in Illinois that basically says that any transfers in a will of $20,000 or more to a non-family member caregiver there's a rebuttable presumption that those types of transfers are void. And the idea is to kind of prevent fraud and people who have influence over these people from taking unfair advantage of that influence when the person is mentally weak towards the end of their life and causing that person to transfer money to them in their will. If the presumption arises, the rebuttable presumption that these transfers are void, then the caregiver has to show by clear and convincing evidence that the bequest was not caused by fraud, duress, or undue influence. So the idea is we don't want to have someone who's been hired to care for this person or anyone that's not a family member basically take advantage of their position in order to steal money and have the person who's passed away transfer the assets to that person in a will when they're not mentally strong enough and don't have the mental capacity to know exactly what they're doing. So that's really all you need to know about lack of testamentary capacity. Again, we have lots of articles on learn-about-law.com about probate litigation, will contests, and all the other causes of action we discussed. So thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.